So, to what extent should judiciary really interfere in religious matters? Where should one really draw the line?
In our constitution, there are two very important articles on the right to practice and propagate your religion, which is Article 25 and 26. 25 is a right of an individual to freely practice and propagate his religion, and 26 is primarily the right of a religious denomination to practice and propagate its religion. So basically, these are two slightly different rights. For a denomination to decide how the religious ceremony would be performed, or where it would be performed, or what is the essential part of the religion is a fundamental right. So really speaking, the religion decides or the denomination decides what according to it is the most sacred part of the religious activities, and to preserve that right is the fundamental right. Now, a recent incident has happened in Chennai, which has become very big news, and I think it's gone all haywire because of mishandling at some level. A individual comes to court and says that I want to light a lamp at a place other than where it has been lighting the lamp for the last 150 or 160 years, more than 160 years. And the High Court, in exercise of its writ jurisdiction, overruling the religious denomination, in this case it will be the temple management, directs that the light should be lit at that other place. Now, the High Court, in my view, has gone wrong in several ways, not one but in several ways. Firstly, whether the light should be lit at X place or Y place is itself a fundamental practice of the religious denomination, and it is only for the temple authorities to decide, or the priests to decide, or whoever is the person who can be said to be the main person of that or committee which is of that denomination to decide. So this is not a justiciable matter at all. This should have been left to the temple authorities, and that is what the High Court on earlier occasions had done in this case also, in 1996 as well as in 2014. In this case, the High Court assumes this jurisdiction upon itself by not declaring that there is any Agma Shastra or any religious reason why in which this lamp should be lit at the hilltop. So he doesn't say that there is anything, and he rightly says so, because there are earlier High Court judgment which says that there is nothing in the Shastras which say that this light should be lit anywhere else where other than where it is being lit at the moment. So that was not the case of the petitioner. The petitioner, in his representation just a couple of days before the matter went to the court, had not even named this place where he wanted to light this lamp. In the writ petition, he suddenly gives this place where he wants to light the lamp as a place called Deepathun. And the High Court judge, not in exercise of article either of excising the or giving the benefit of the fundamental right either under Article 25 or 26, because there is no religiosity established in the proceedings by that individual of lighting that lamp at that other place, simply because this place is adjoining to a dargah, and he goes completely haywire by saying that it may not be a religious necessity or religious essentiality to light that lamp at that other place where the petitioner is wanting to be lit. He doesn't even cite that there is any custom or tradition or any historicity of lighting that lamp at that particular place where the petitioner is wanting it to be lit. But he decides the writ petition as if the light is lit at that other point, which is on the hilltop, which is next to the dargah, the Hindus will be able to consolidate their right on the property of the temple, which is the entire property which was decided in a decree of 1923 by the sub-judge of that area. And he says that by exercising this right, you will ensure that the property of the temple is intact. I think this is something which is contrary to what the judge should be doing in deciding a writ petition, because a writ petition under our constitution is maintainable for at the behest of any person if he has an individual right or if he has a fundamental right. And it is only that if you have a particular legal right or a fundamental right that you can enforce that right by filing a writ petition and asking for a mandamus to enforce that particular right. In this case, the petitioner has not been able to establish any right, neither a fundamental right nor a legal right, but simply because the petitioner has given this name Deepathun in the writ petition, which name was never there in any earlier litigation or even in his representation, which came a couple of days earlier. And the judge says that Deepathun by its very name means lighting of lamp. And since Deepathun means lighting of lamp, then it is res ipsa loquitur, and that lighting of lamp should be done there, and it should be also be done because that way the temple will be asserting its property rights over the entire of the property decreed by the Privy Council in favor of the Hindus, and there will be less likely intrusion onto the right of the Hindus in the preservation of its property by the Muslims. Now, this is something which is very, very dangerous, because it's dangerous because in the decree of 1923, the particular flight of stairs which is supposed to be used as per the High Court judgment for the purposes of going to this so-called imaginary place called Deepathun, is partly owned by part of the stair is owned by the Dargah as per the decree. So, if you are forcing people or if you are directing the temple authorities to use a particular stair which is already decided to be within the ownership of the Dargah, and go and light a lamp at a place where it is not provided in the religion to be lit, and the lighting of the lamp itself is an annual ritual where lakhs and lakhs people congregate, and when lakhs and lakhs people congregate for the lighting of the lamp at the place where it is being lit now, requires a massive amount of arrangement. People have to be given enough space to congregate and to witness the lighting of the lamp. Now, to say in a writ petition, discarding the stand of the state and the authority that there is no religiosity in lighting the lamp at the hilltop next to the Dargah, and without appreciating the public order involved in organizing this kind of a lighting of lamp, the High Court goes very, very wrong in directing this lighting of lamp at that hilltop. Just imagine if lakhs and lakhs of people have to go on a staircase which is leading to the Dargah as well as to that imaginary place called Deepathun, and there is no place to congregate there for those lakhs of people at the hilltop. And if there were to be stampede, then just imagine the kind of accident that could happen, affecting or adversely affecting lives of thousands of people who come annually for this kind of a festival. The learned judge also went on to say that this lighting of lamp may be done at the traditional place where it is being done, and also additionally at the hilltop. Now, the fallacy of this is also very fundamental, that if the lighting of the lamp is an annual ritual which the people of that area consider to be their fundamental right to witness as part of their religious activity, which is a fundamental right under Article 25, then to say that you will light the lamp at some other point and not allow the people to go there at the other point is also violating the fundamental right of the people who have a right to witness a religious function in the temple. Whichever way you look at it, this judgment is completely flawed, and this judgment, according to me, sets a very bad precedent of courts, sort of getting involved in the flaring up of communal tension, where there has been none for at least more than 170 years since the lighting of the lamp is being done at the place where it is being done now. And the two communities living in complete harmony at that lighting of lamp, and nobody except that one individual who went to the writ court is having any problem with that lighting. To suddenly say that it will be lit next to the Dargah and use the stairs which is owned by the Dargah, and provide that lakhs of people will go up the hill for the lighting of the lamp, or even if lakhs of people don't go, anybody else going for the lighting of the lamp, which may which may flare up communal tensions also, is actually deciding something expressly contrary to Article 25 and 26, because both the articles start with the clause that subject to public order, morality and health. Now, if the public order doesn't permit possibility of lighting of lamp there at the hilltop by using these stairs which are owned by the Dargah, then the High Court saying that the light should be lit there, I think is completely contrary to the very spirit of that article. So I think this is a controversy which has become a very important national controversy. People are considering this controversy as if it is a issue between two communities when there is none. The communities are absolutely at peace. The High Court judge, incidentally, is part of that organization who delivered this judgment, who prior to this elevation had been part of that Hindu Muniri, which has been protesting for lighting of the lamp at the at the hilltop. And if the judge was part of that organization and he has been advocating for that cause of lighting of the lamp at the hilltop, being a member of that organization, ideally, and that is how the judiciary has behaved over a period of time, that he should have recused to hear this matter, because he has an interest in the matter. And the way he has delivered the judgment, the way he has gone ahead with the proceedings, the way he has been completely oblivious of the issues involved in organizing this kind of a lighting of lamp, because even in the earlier litigations in 97, 96 and 2014, the court, when asked to direct the lighting of the lamp at the hilltop, the court had said that it is always open to the temple management if it wants to do so, and it had always left it to the authorities to take a call, because such a kind of a direction to be issued for lighting the lamp 3 days after when the direction was issued, completely mindless of the logistics involved in making such preparation for lighting of the lamp, and without the consent of the temple or of the authorities, was according to me something very, very wrong. And this is definitely not what the High Court should be doing. In fact, the High Court is a guardian of public order, and if the state were acting in a manner which could disturb public order, it is the duty of the High Court to ensure that public order is not disturbed and restrain the state also from doing something like that. And here the High Court itself is passing orders which has the huge potentiality of disturbing public order, which directly includes communal harmony. I think this is something which people of this country should know, that how high courts can go so horribly wrong in religious matters. And this, according to me, is a test case. Fortunately, the division bench has heard the matter in appeal and it has reserved judgment. I hope sense will prevail in the division bench and this judgment is set aside as soon as possible.
Thank you, sir.